Hi guys, good morning. Welcome to the channel. My name is Niladri Mukherjee and I'm a regulated Canadian immigration consultant. I practice here in Guelph, Ontario. So today's video, I thought to talk a little bit about what options do you have on the table and to analyze those options in a little more detail if your study permit application has been rejected. Okay, so once you have received your study permit rejection letter, if you scroll through the letter, the very last line of your rejection letter will tell you the option, the workable option that you have on the table. And most likely the very last line of your rejection letter will read something like this. You are welcome to reapply if you feel that you can respond to these concerns and demonstrate that your situation meets the requirements. So the officer has highlighted obviously a couple of points of concerns for you. Those points may be like officers do not believe that you will leave Canada at the end of the stay because of maybe your personal assets, because of maybe your home ties, because of maybe your travel history, your language requirement, improper course selection, and so on and so forth. So in short, whatever that you see on the very last line of your rejection letter, that gives you to the next step, which is for most of you, at least for 90% of you, would be a reapplication. Now, what is a reapplication? Reapplication means that you are able to, so you are given an opportunity to basically rectify the mistakes which the officers believe that you have done in your previous application, and to submit a new application from the very beginning, accompanying with a new application processing fee, right? So how would you take this whole project? First and foremost, the step number one is for you to apply for GCMS notes, the Global Case Management System notes. The one-pager rejection letter that you receive most likely will just give you some boilerplate reasons and will not give you detailed explanation as to why the officers have thought so. For example, if the officer did not believe that you will leave Canada at the end of your stay, the notes will give you the detailed reasons as to why the officers have believed so. Is it because of your improper home ties? Is it because of your lack of travel history? Is it because of whatever reason? Those reasons will be clearly mentioned on the notes. So the very first and foremost thing for you is to get access to the notes. Once you get access to the notes, it is important for you to obviously go through the entire note and to understand and to analyze it. And if you're not able to do it yourself, if you're not able to understand all the legal terms that are being mentioned on the notes, feel free to book a legal consultation. I'll be more than happy to help you out with. If you're able to do it all by yourself, you can do it by yourself, obviously. The third step, once you have understood the reason for the rejection, as the officers must have mentioned on the notes, you can then prepare your application kit one more time and then resubmit the application along with a new letter of explanation, along with a new processing fee, and by making sure that you are able to rectify the mistakes that the officer has pointed out in the previous application and are able to submit a foolproof application. Now, this is very important because the more number of times that an application gets rejected, the less chances of acceptance that you have in the next time that you reapply for. In other words, the first time that you apply for your study permit application gives you the maximum opportunity of success, and every time you reapply, it is that much lower. Having said that, reapplication, a properly made reapplication, a properly made application is always gives you enough opportunity for the officer to completely review your file and gives you to give them to make a proper decision on your behalf. And I have seen from my personal my personal experience is that for well-made application, for well-made reapplication, the possibility of success is generally quite good, right? So this is probably what you should know in a nutshell if you talk about the reapplication. So this is the immediate step that 90% of you should follow. Now, I get this question quite a lot that, hey, Niladri, you're talking about reapplication, but do I have any other option? For example, can I go to the Federal Court of Canada to appeal to the decision, right? So then my short answer to those questions will be no. As a foreign national, what you have to understand is that Canadian visa is not your right, it's your privilege. This is how government wants you to interpret that, and hence the government of Canada does not give you any legal right of appeal if any visa, it is not only about study visa, your immigration, your work permit, or your study, or your visit visa, any visa gets rejected, you do not have any appeal right. What you can do, however, is that as per section 72 of the IRPA, is to seek a leave for judicial review from the Federal Court of Canada. What do I mean by that? It means that you are asking the Federal Court of Canada to assign another officer, to assign another IRCC officer to take a relook of the same rejected application. Okay, so in this process, so this is not an appeal by any means. This is called a leave for judicial review, which means you're requesting the Federal Court of Canada to just assign another officer to take a relook at the already submitted application, which was rejected by an IRCC officer. Right? So this is what a judicial review is. Now, who can help you with the judicial review, right? But before I come to that, this is very important for you to understand that you are not able to submit any new proof, any new supporting documents at the time of your judicial review. Judicial review is simply requesting the federal government, the Federal Court of Canada to assign another officer to take a relook at the same application. But no, you are not legally allowed to submit any new proof, right? So really, who can then help you with the judicial review process? If you are well versed with the Canadian immigration law and the regulations, you can do it yourself. If you want, you can get engaged with the Canadian immigration lawyer to do it for you. Or if you want an IRCC's, an ICCRC licensed immigration consultant such as myself can help you with the judicial review process as well. It's a very common notion that, only Canadian immigration lawyer can represent their clients at the Federal Court of Canada for something like judicial review, but this is not true. A licensed immigration consultant here in Canada has the legal right to represent clients in the Federal Court of Canada for something like judicial review. I am not an immigration lawyer, I'm an immigration consultant, I am licensed by ICCRC, and I have the legal right to represent my clients at the Federal Court of Canada for judicial review process. In fact, I have done it, and I have done it with success. I am proud to say that, right? So this is what a judicial review process is. But then why did I talk about reapplication first and not a judicial review? Because IRCC is asking you to reapply and IRCC is not asking you to go for judicial review. And that is for a couple of reasons. One, reapplication means you have the opportunity to submit anything that you want at the time of your reapplication and to like a new letter of explanation, like a new language test, for example, or anything else that you think should justify your reasons to be a bona fide student here in Canada, right? So, a reapplication gives you a way lot more opportunity, to completely resubmit your application with a new letter of explanation. A judicial review does not give you that opportunity. Number one is the cost. A judicial review process, if you're not doing it all by yourself, and most likely you will need a professional help here, is quite an expensive process. I can give you a live example. You must have gone through my website, and I'm quite transparent with my professional services fees, etc. It's all available in public domain on the website, and my fees are quite reasonable in light of the industry, but still I charge over 4,000 Canadian dollars for a judicial review process because this is a very complicated process. It takes a lot of time, right? And thirdly, and most importantly, you are simply requesting the Federal Court of Canada to assign an officer. And no matter how well made that leave for judicial review is, that application for judicial review is, there is no guarantee that the Federal Court of Canada will request another IRCC officer to take a relook at the application, which was rejected by his colleague or her colleague, for example. Now, the court cases are already in the backlog, right? So there is a very little probability that the Federal Court of Canada is going to grant a judicial review application in the times of COVID at least, right? So these are the couple of flip sides that I personally think a judicial review process has. Now at this point in time, I'm probably talking against the industry because it is a reality that like the processes such as this, like the judicial review and the appeal, etc. This is the process that really help the immigration consultants and lawyers to make the most number of money, the most amount of money. But my objective is to let you know, as an immigration consultant, as a licensed immigration consultant, knowing that a judicial review process will give me far more money if you need my help, that is. My objective is to let you understand or to let you know what you can do by spending less amount of money with that probably gives you the higher chances of success. Nobody wants to go to court. This is a reality. Nobody should go to court. You should submit your application in such a manner that you do not have to go to court. I have the legal right, I repeat, I have the legal right to take you to court, to represent you in court if you are my client. And I will take a lot of money from you for doing that. But I am requesting you to submit your application in such a manner in the very first case, or maybe in the reapplication process, that you do not have to resort to these options, because these processes are expensive, and secondly, you will spend a lot of time in the back and forth. You don't want to do that for sure. So that boils down to the conclusion of the video, which means that the logical and the workable option that you're looking at is to reapply. If you are confident in doing that process yourself after you having access to the GCMS notes, this is very, very important, and I cannot stress it enough. Get access to your GCMS notes. Do not reapply without having the GCMS notes, right? So if you think you are confident enough to reapply all by yourself, you are mostly welcome to do that. If you need my professional assistance, please feel free to drop me a line. I'll be more than happy to help you out with. Thank you very much, and I'll see you in the next video. Bye now. Stay safe. Thank you.